Ladies and gentlemen, can I have your attention and we'll start. The next speaker on our program is James Wardlaw, QC, and Jim's topic is dealing with the family business interests. Mr. Wardlaw was born in Orangeville, attended high school in Orangeville, and presently reads the law in Orangeville at the firm of Wardlaw, and Mullen, and has been doing so since joining that firm in 1956. Jim is a bencher of the Law Society of Upper Canada, and he is the past president of the Dufferin County Bar Association. He is also an executor on every will in Dufferin County. He is chairman of the Wills and Trusts section of the Canadian Bar Association, and he also, like some of our other speakers, is head of a course at the Bar Admission course, namely state planning, and I imagine he is unique in that he's the only out-of-town one. He travels back and forth from Orangeville to Toronto to head this very important and long course, the Bar Admission course, and is, in my estimation, one of the hardest working lawyers there is. Combined with that, he took a canoe trip this summer up the Coppermine River to the Arctic Ocean, and I suspect it was to scout locations for new branch offices. I don't know, but he came back with a wonderful beard, which we don't have, unfortunately, anymore. I give you Jim Wardlaw.
Thank you, Burke. It's obvious that the organizers of this program recognize a coffee speaker when they see one, and if you wonder what a coffee speaker is, it's who's next on the program. It's Jim Wardlaw. Let's go have a coffee. Fred Baker, the late Fred Baker, used to start papers like this with comments that the errors in the paper are intentional to see if you're awake. And I preface my remarks with that. You have in front of you a skeleton of the comments that I'm supposed to be making. That is a skeleton, and before I get to the skeleton, I'm going to give you some flesh for it to sort of make it relevant to your own practices. Now, the things that I have to say so far as the flesh is concerned are probably self-evident to all of you, but perhaps you haven't had them put to you in so many words. And so I'm just sort of going to review these problems as I have observed them in dealing with family business interests. A lawyer normally becomes involved with a family business at the point that the proprietor of an existing business comes in to see him about one of two things: either making a will or introducing a child into his business, or alternatively disposing of a business to a stranger. But it is a family business that he's disposing of, and I'll get that one out of the way first. The problem that I find with a family business is that he doesn't want to let go, in the sense that he wants something to do. And as a result, he is willing to take something of a lower price on the basis that he's going to be retained as a consultant, and he's going to get paid so much as a consultant for a couple of years, and he really feels good about that. So he'll take a lower price. Now, my experience in that is that the purchaser is delighted to pay him the lower price, the difference in consulting fees, because he gets a write-off of those consulting fees against income tax, and as soon as the deal is completed, so far as consulting is concerned, he hopes the guy is living in Timbuktu, because he's got no more interest in him being there in the business than flying to the moon. Now, let's get that one out of the way, or it's now out of the way. He's now in the position of bringing a child into the business. And he is faced with conflicting desires. He wants this child in the business with him, but he also wants to treat all of his children just the same. He wants them all treated equally. And how does he go about it? Now, it is my view, at least, and because it's my prejudice, it's the way you're going to hear it, it's my view that the solution to this problem lies not in dealing with the business interest in the will, but rather in dealing with the business interest on an inter vivos basis and introducing the child into the business during his lifetime. Now, this, of course, is an indication only of the general approach. It obviously ignores the problem of the surviving spouse, and that interest has to be taken into account. And it, of course, ignores other matters which I'm going to refer to right now. The first thing you've got to really be sure is that the child really wants to go into this business. If he's a kid that's just out of high school or just out of university, how does the father really know he wants to go out of this business? Now, I come from small-town Ontario. I'm not dealing with the big corporations, but I suspect that what I'm dealing with is normal small business in the city as well. And the child goes into the business with the father proudly expands the business, and then about 3 years down the line, child decides, my God, I want no part of this, and leaves. And father at that point really doesn't have the vigor to carry on the expanded operation and has to dispose of it to the stranger that I first spoke of. So the first word of warning then is to make sure that the child really wants to go into the business and to go slow. Have him in there on an employee basis for a couple of years first, and perhaps then go into a partnership. Now, this is my second point, and that is the type of business arrangement that you go into. Now, I don't want to knock the corporation because of its many obvious advantages, but one of the things that we lawyers tend to do is to pay nothing more than lip service to the disadvantages of a corporation. And one of the major disadvantages to a corporation is how to get out of it if there is a knockdown family fight. How do you wind it up? And this is not as easy as just going to the court and getting a declaration that it is just and equitable so to do, because if there is someone who is really wanting to be nasty may be able to block that. So it may be to advantage in your actual flesh situation to go into a partnership for a short period of time to see if the business relationship is in fact going to work. Now, I suggest that, of course, if the business is not already incorporated. If the business is already incorporated, that obviously doesn't apply. Now, the third, or another word of problem, or another word of caution, has to do with shareholder or partnership agreements and the buy-sell provisions of such agreements. I have heard so many lawyers say when they set up a corporation or a partnership, well, I'm not worried about the situation as to what's going to happen with death, because we know that the older parent is going to die first. We know that the son is going to stay in the business, so we don't need a shareholders agreement. And I suggest to you that, at least in the problems that I've had, that is not so. More than ever, I suggest, in a family business situation, business should be done in a business-like manner. And there should be a buy-sell provision. We cannot assume that the parent is going to die first. We cannot assume that one of them is not wanting to get out in a couple of years. We cannot assume that one of them is not going to become incapacitated either through accident or illness and still be entitled to carry on or to take a share of profit. I suggest that it's very important to have a shareholders agreement. I suggest that this is true even in the mama-papa type of business, where the only reason you've incorporated is to get a tax split. Because in this day of marriage breakdown, we have the situation where who is going to get that share? And I suggest that we should have incorporated into a buy-sell agreement or into a domestic contract or whatever you have, a provision that says that if Mama is a shareholder, that Papa has the right to buy her share out, or alternatively, Mama has the right to require Papa to buy her out, and accompany that with a provision for valuing that share, whatever that provision might be. We also have the problem of the son coming into the business. Now, don't get me wrong. I think that it's tremendous that sons do come into business, and in many small businesses, he is the logical person to come in. But I suggest to you that it's a good idea that he get experience outside of the business, that he work for someone else for a period of time before he comes in. Because if he doesn't, he's going to be under Papa's thumb. Now, I don't know where I was. I've forgotten the circumstance. I just remember what happened, that at some talk that I gave at some point, I obviously hit a note. And the father owner of the business came to me and said, "You're right on. I want you to come and talk to the boy and let him know." Now, it turned out that the boy was 10 years older than I was. Well, I'll leave that one alone. Now, father has to be prepared. Oh, all right, let's go to these competing family interests. Sometimes you're talking to father and you're trying to find out just how his business operates. And you get sort of a mental picture of the business structure. And you have father, who owns the business, on an organizational chart, standing up here about where my head is. And he's got son standing out here as a sales manager, just about where my fist is on this. And son has been a graduate of maybe grade 10, and he came into the family business, and he's been with father ever since. And then we've got son-in-law somewhere down here. And son-in-law's, he's never going to fit into this business. He's got a master's degree in business administration from some fly-by-night U.S. outfit, for God's sake, Harvard, I think they call it. He'll never make good in our, his ideas just won't work in our business. Now, if you've got that problem, and I'm sure you have run against it, it's obvious that you've got to, if you yourself don't talk to son-in-law, you've got to get it through the accountant, that son-in-law really doesn't have any future in that business at all, and he'd better get out. And the sooner he gets out, the better. We've also got to make sure that father knows he's got to let go. Father has got to say at some point, when I'm 65, when I'm 70, but at some point, I'm going to leave, and it's going to be yours. And between now and then, father has got to allow the son to make decisions. Now, that's not too hard. He's prepared to at least pay lip service to that. But he's got to be prepared to make his son, or have his son, make wrong decisions. How many of you have learned from your right decisions? How much more have you learned from your wrong decisions? And I think that's really what you've got to be able to impress on father. And if father isn't prepared to let go, or if son has always been under the thumb of the father, you can be damn sure that that business is going to go down the drain once father is gone. Now starting to get to the skeleton of some of this problem. Assuming we're doing this on an inter vivos basis, the great problem lies with Section 69 of the Income Tax Act. And Section 69 conceptually says this, that if father conveys to son a business interest, now I'm using the word business interest as opposed to shares of a corporation or an interest in a partnership. I'm just using business interest as a generic term. If father conveys to son a business interest, and that business interest is greater now in value than it was on December 31st, 1971, father has incurred a capital gain, and 1/2 of that capital gain is going to be taxable in the year that he transfers that business interest to his child. Now, father is quite prepared to do this until he learns it's going to cost him money. It's all right to give away something because it's money he hasn't actually got in his hands. When he realizes he's going to have to spend money out in tax dollars, he gets upset. And may I indicate to you that this presumed, and I might say that the words in the section are that it's a deemed disposition at fair market value. You don't get away from this. It's deemed to be at fair market value, so that you can't convey it for something less than fair market value and say, will that do? It is at fair market value with all the tax consequences that flow from that. And secondly, the Act goes on to say that related persons are deemed not to deal with each other at arm's length. And then in any other case, it's a question of fact. Now, the solution to this problem lies under two general headings. The first solution lies under the heading of, quotes, reserves, and the other general solution lies under the heading of, quotes, rollovers. Now, it may be that in using either of these, you will import concepts from the other and use techniques from the other, but they are really both two types of solution. Now, first of all, I want to deal with reserves. If a property, and let's just deal with strangers. If a property is sold that has a capital gain in it, and it is sold for cash, it is obvious that the taxable capital gain from that is imported into income in the year of the sale. Suppose that he takes back, instead of completely cash, he takes back a security in the form of a mortgage or a note or something else. He is then entitled to set up that security as a reserve. The department takes the position that part of the cash is his cost base, part of the cash is capital gain. Part of the mortgage that he takes back is cost base, and part of the mortgage that he takes back is capital gain. The idea, though, is that the whole of the capital gain is not taxed at the time of the transfer, but is only taxed as that security is paid. Now, I don't have any things to flash on the screen to show you the calculation of this. I'm merely giving to you the concept. Now, the same sort of thing applies with the child in a non-arm's length transaction. If the father takes part cash and part mortgage, the same thing applies. But if you look at the formula and you had the father selling the business interest to the child and the father taking back a security equal to 100% of the sale price, then it's obvious from the formula that your sale price that your reserve is equal to 100% of your capital gain. Therefore, father sells the business interest to the child. The child pays for it by giving him a mortgage equal to 100% of the business interest, and father's problem is solved at least on a temporary basis. The temporary basis being that he doesn't have an inclusion in income that year. Now, what can father do with it? Well, he can forgive small amounts of that security each year on such a basis that he doesn't suddenly jump several tax brackets while he does it, and dispose of it that way, because as he makes a gift of the security that he takes back, some tax comes in. Alternatively, he can just continue to carry it forward and presumably at his death convey it, or at least devise it or bequeath it in his will to his spouse. And then there's no capital gain come in then, and then it comes in at the time of the spouse's death. So he has a long deferral of that. Now, how long you're going to get really depends on what the Department of National Revenue will let you get away with. And there was another income tax bulletin on this exact point last August, and it was Bulletin IT 436. So you may not get away with an indefinite postponement of it, but you will get away with something, some of that deferral. Alternatively, father may see a year in which he's going to lose a lot of money and have the money come in that year. Eventually, however, it's going to come in. He doesn't get any more than a deferral. Now, the child has a problem if father adopts this procedure. And the child's problem lies under Section 80 of the Income Tax Act, which says that if a gift is made of a debt, in other words, the debt is extinguished by way of gift, then the cost base that the child has on that asset is eroded to the extent that a gift is made. So, for example, suppose father sells this business interest to the child for $50,000, and suppose his cost base on it was $20,000, and then he is forgiving this at the rate of $5,000 a year, and at the end of 10 years it's down to zero. Child's cost base has come from the original $50,000 down to zero. Father will have already paid capital gains tax, or at least he'll have an inclusion of income on the difference between $20,000 and $50,000. When the child goes to dispose of that asset, he's going to have a cost base of zero. So he's not only going to pay capital gains tax on what his father has already paid, but he's also going to pay capital gains tax on his father's cost. Now, obviously, this creates a problem of double taxation. Hopefully, that problem can be solved by the system adopted under the Ontario Succession Duty Act, under the premium payment test, when we dealt with life insurance policies. And briefly stated, and simplistically stated, it is this: that the child pays the security and the father, the child pays the security and the father makes gifts of cash. Now, if you do it just flat, like that, if you make it that artificial, that simple, the Department of National Revenue is going to look right behind it. They're not going to pay any attention to it, and you're not going to achieve what you're hoping to achieve. Check kiting, I think it used to be called, although I haven't heard that phrase for a long time. If there's just 2 checks crossing in the mail, forget it. I suggest that you may, and I don't know that you can. We used to get away with it in Ontario under the Succession Duty Act, but that was the Ontario Ministry of Revenue. We are now dealing with the Department of National Revenue, a different taxing body. Hopefully it will work. As I have spoken to various assessors with the Department of National Revenue, they say to me that is a proper way of avoiding it. But this is strictly administrative. I don't know if it will always work. But use the following techniques, I suggest. First of all, there is a difference between the amount of the gift and the amount of the cash payment. Secondly, there is a difference in time. The gift, and I suggest that the payment should be made first, the payment of the note made first, and then some time elapses before there's a cash gift. Thirdly, that the cash gift be made on a gifting occasion, Christmas, birthday. There's an alternative suggestion in that no gift of cash may need be made at all. Rather, the father assumes the child's responsibility for some of the child's debts. The father might pay the mortgage for the child on the mortgages on the child's house. Now, if this is done, hopefully, the child's cost base is not eroded. Now, the department is not too happy about losing its tax on the basis of reserves and non-arm's length transactions, and as a result, it is prepared to make an attack. And its attack is on several bases. The first basis of attack is on valuations. Are you using proper valuations? And my suggestion to you is, if you're dealing with something as simple as real estate, you know enough to go out and get a good, solid letter of opinion calling the comparables. if you are dealing with business interests, then if your accountant is not attached to a big firm like Coopers & Lybrand or Price Waterhouse or something of that nature, you should strongly suggest to your family accountant that he calls in the business valuation unit of one of these big accounting houses and ask them to do the business valuation for you, so that you have some real expert testimony in case of need. Remember, this is not a case where you can get pre-clearances on the valuations that you use. I might say to you that a useful case on valuations of shares, business interest shares, is Rewrite, 1977, 14 Ontario Reports, second edition at page 698. Now, once this value has been determined, you've got to prepare an agreement of purchase and sale, setting out this value and how you arrived at it. But you've got to go further than that. You've got to put into this agreement of purchase and sale something that's called a price adjustment clause. Now, this price adjustment clause is a clause which says that if the Department of National Revenue disagrees with this, and either by settlement or by court order a different valuation is achieved, then the parties agree nunc pro tunc from the very beginning that that was the actual price intended. But the price adjustment clause has to go beyond merely saying that is our original idea. It has to go on to say or provide for a mechanism for achieving that difference. You will be surprised about the agreements that are there merely with the price adjustment clause saying we agree that we will change the price, but the department still tries to levy tax because there is no mechanism for making the change. So the mechanism for it has got to be in there as well. We'll increase the mortgage, or we'll have a mortgage amending agreement, or if the mortgage is paid off, we'll do a new mortgage, or if it's too much, we will reduce the amount of the mortgage, something like that. Then you have to, in addition to this, notify the department with the next income tax return that there is a price adjustment clause in an agreement. Unfortunately, the department was running across the situation where people were manufacturing evidence after the event. So they want to know, in the year that an agreement is entered into that has a price adjustment clause, that such a price adjustment clause has been entered into. Now, it's all very well for you to say to your client in your reporting letter, make sure that you do this, that you report this price adjustment clause in your next income tax return. You know damn well he's going to forget it. So I suggest that you should write a letter at that point and send it to the department, giving the income tax account number, giving the social insurance number, and saying these parties have entered into an agreement containing a price adjustment clause, and put that in their records. I've had personal experience with that. I know that my clients forgot. I know we're still all right because the department was on notice. Another form of attack comes on the form of the security. It's all right, Mike, I'll be through in 4 minutes. Or, not Mike, sorry, Burke. The form of security. Now, first of all, your client is not going to want to have interest paid on that security because he doesn't want to have an income inclusion on his part. We have a very nice case, the Minister of National Revenue and Smith, Federal Court of Appeal. Unfortunately, tax cases now don't go much beyond that level very often. Mr. Justice Urey saying in 1975 in the Federal Court of Appeal The failure to charge interest on the unpaid balance of the purchase price never has, at least of itself, cast doubt on the bona fides of a transaction. So you don't have to charge interest, and there is judicial authority for it. The second problem, though, is that the client wants maximum flexibility in dealing with this security. He doesn't want it a term note. He doesn't want it a note that comes due in 5 years' time, because in 5 years' time he's got to do something with it. I suggest to you that what he wants is something that he has real flexibility with. He wants it payable on demand so that he can deal with it when he wants to deal with it. Now, we have the problem of limitations, as you are aware, after 6 years. So I suggest that you make that security payable under seal. If it's a note, certainly add a seal to it and increase your limitation period to 20 years. Now, the problem, though, is that if it's payable on demand, a reserve cannot be set up. A security that is payable on demand is regarded by the department as being the equivalent of cash, because it can be demanded immediately. Now, the Act provides that a reserve can be set up only if it is not payable until a day that is after the end of the taxation year. The security must therefore be structured so that it is payable a year and a day after demand, or 367 days after demand, to take into account leap years. Now, I know that there are many notes floating around this city that say they are payable 10 days after demand. And the theory on those was that you look at it at the end of the taxation year, and you see at the end of the taxation year that if you call it, it's not due that year, so you can still set up your reserve. And that, I know that there's a lot of those floating around, but the change in the interpretation bulletin that I've already given to you indicates that the department does not buy that view. The department says a year and a day, and I suggest that you may have a problem if you've got a one that is payable on demand. I suggest that you look at Interpretation Bulletin IT 436 very carefully and see if there is some system that you can use to replace one note with another and still get the advantage of the department. It might be wise to say to the department on a no-name basis, I have this situation, will you buy it? Will you buy a change? And then get a ruling if they say informally that they will. Now, I'm at the end of my time. Obviously, I've no time whatever to talk about rollovers. There are 3 general types, but it'll all be in the paper, and such is the word at this point from small town Ontario. Thank you.